Hello, everyone. Welcome to this webinar we have today. This is Hamid Cohen from LegalSoft, and I'd like to welcome everybody on board, having a discussion about the new changes that is taking effect, maybe it takes effect by November on the November California ballot. And I just wanted to explore what's going on, what's the impact, and what kind of recommendations we have going forward. So just starting up with the ballot, this is something where Uber campaigned for and was able to put uh, on the ballot for the November voting in California that limits put a cap on attorney and the physician fees on the personal injury cases. A lot of the PI firms in California are campaigning against it, and there's coalitions who are working to sort of defeat this ballot. So as a legal soft, we work with 1,000 law firms, hundreds of PI firms in California are our client. So we're definitely going to see an impact with this industry if the ballot passes. And if it does pass, it will create a huge challenge for personal injury firms in California, as basically going from almost 70% fees that is going to the physicians and medical providers and attorneys to 25%, which is a very drastic cut. So it's going to affect all PI firms in California if it actually passes. The way it's written, I actually be surprised if it doesn't pass, because it's asking people if the attorneys and medical providers should take bulk of the fees that is recovered, or cap it to 25%, which means the plaintiffs will get the majority of the fees that it was collected during pre-litigation or litigation of the cases. This is going to be a huge impact. So as a result, a lot of the PI firms have come to us and asked me personally, or the company, so what do we do to get prepared in case this ballot passes? Which again, I really think it has a good chance because the way it's written and the way it's supported, and it's going to basically ask people what they like to see done. So as a part of this process, PI practices in California are trying to pivot from California personal injury, and they are essentially looking for consultations. And so what do we do in case this passes? If it doesn't pass, it's still not a bad idea to be diversified, because if this doesn't pass, they're going to come at it again some other way, because they think the personal injury attorneys in California, are basically overcharging, overtaking, and a whole bunch of other reasons. So, in my opinion, even if this one doesn't go through, there's going to be one right behind it, supported with ride-sharing companies, the Lyft and Uber and insurance companies and so forth. They're not going to let it go. From what I've seen that happened within lemon law industry in California, employment in California, a variety of different things. As soon as they see that the cost of operating in California with these insurance companies are going up, they usually run a campaign to limit it. So this is I guess, the million-dollar question. And what do we do? We have a few suggestions. We actually implemented with several PI firms in California. We implemented some of this, what we call a pivoting, to get prepared in case this happens. And even if it doesn't happen, it's still a good pivot. So one pivot is, it almost seems like every PI firm in California wants to pivot into an employment firm and set up an employment practice. Obviously, employment law in California is very favorable to the employees. So there's really not a shortage of cases at this point. It's going to get more challenging on how to get the cases, and how much the cases cost and what's the recovery. So it is a good pivot, and we have helped a whole bunch of PI firms to pivot to employment. The challenge within the PI going employment, The way I categorize it is like somebody that's speaking English and all of a sudden they got to really just be very fluent in French. Um, because it's almost not no similarity between a PI firm and employment firm. PI firm, when the case happens, is very obvious. Somebody rear end somebody, the injuries are there, the PD is there, the insurance coverage is there, whatever. You just take the case forward. In employment, everything starts with story. We don't know if it's a story, if it's a drama, it's imagination, where are the facts, where is the evidence, and so forth. It's very difficult, and it has so many different stages that a lot of the PR firm that I speak with, they don't quite understand the process of the employment being pre-litigation is one category, and then you have wage and hour category, then you have single actions, which is like sexual harassment, wrongful termination, discrimination. Again, each one of those on its own is a different practice type. Then you get into litigation. Then you get into arbitrations and a lot of mediations, and then getting prep, and then all the way in the end where you have class action employments, which is a PAGA. And the rules in employment changes a lot more than it does in PI. There's a FIA cases, PAGA cases, and they keep changing the rules, basically. Labor codes are changing, adding new labor codes. So it is an alternative to actually go start, but you have to be very careful on how you set up the infrastructure. It's not a PI firm anymore. You can't just duplicate the PI into employment. You almost got to write the whole new recipe, and we can definitely help you with that because we have a lot of employment firms that we work with. We've started a lot of them. But I just want to put a caution out there that is not the same. So please don't treat it as the same. I'm just going to go buy some cases and then I sell them and I get the fees. It is more complicated than that. So that's definitely one pivot. And also, when you're doing the employment, there's a lot of referrals opportunities and so forth happens because you can't cover the entire employment practice from end to end. So you started slowly with the pre-lit, and so you got to refer out some litigation cases, class action cases, and the workers' comp cases are some derivatives of the employment. So you got to be able to refer that out too. So the recipe and the process and the implementation and the workflow is very different. And you need to be guided through that. And also is one of those areas that recently has a huge extension of having virtual staff doing the work because the talent is very rare. You always thought bilingual case manager with a PI experience was a rare commodity. Just try to find an California employment case manager or paralegal who knows employment labor codes and so forth. That's probably 10 times more difficult. We do have those resources in LegalSoft, and we've been providing it to our employment firms all the way from pre-lit all the way to litigations, and even the class action firms using our virtual staff to help them within discoveries, motions, all of those areas within the employment. So the good news is it's doable. The bad news is it's not as easy as the PI might be. So you got to be careful about how you do that. So that's definitely one pivot into employment within the California, which could be a combination of employment law and the workers' comp. Obviously, you don't want to do workers' comp, but you're going to be referring cases out there where there's an employment code violation, but also involves some injuries that workers' comp comes in and sort of. So you have two cases going on simultaneously. So that's on the employment side. The next pivot that we've been doing that for about 7 years now, but now is becoming more of a urgent thing to do. A lot of folks who practice in California, pretty much California fulfilled all of their the expansions they want to do. The market was here. The money was here and everything. So they pretty much stuck to California. And because of the bar rules that are different state by state, and attorneys are typically licensed in one state, it limited their vision to expand the PI in California. And about 6, 7 years ago, when we discovered the nationwide sort of a practice types, we set up and expanded on hiring universal bar exam, which is essentially there's like 39 states in the US who honors the UBE license, which if you pass a bar, let's say in Arizona or Colorado or Washington or Texas, you're pretty much qualified to practice in 30 plus states. And all you need to do, you need to be entered and you do a background check. There's no bar to pass. There's no getting motioned in or anything like that. You literally license in 30 states if you put your mind to it. So that was one element of expanding to multiple states. And we know the cost of client acquisitions in almost every state. We know what the average time from intake to settlement is, and we know what's the average fee for pre-litigation and litigations throughout the country. The reason we know that because we have clients over in every state. So we are in discussion with them, we're consulting with them, so we know what's going on in those states. Not like a lead generation company would know, but truly the numbers within the firm that are feasible to get. The cost of acquisition, the time, the average time, and average fees for pre-lead and lead. So not doing that, a lot of the traditional process was to go open up an office in one of the states, hire some local people, advertise a market within that state, almost like they did originally when they opened up a firm in California. That's not the case after COVID. We work with a lot of firms who operate multiple states, and their local presence in the state is probably like one person in the office to just show presence. All the case handling happens locally here in California. Intake is, well, usually intake is through legal staff, virtual staff, but the case management, there's a sources to find doctors on lien in almost every state. So there's a directory that you can use to set up all your lien network. And essentially practice remotely from California, but in multiple states. We've done it. We show you how it's done, and it is uh, not very simple, but it's very feasible and doable. So we definitely recommend pivoting to practicing PI in other states that are financially better stage that California going to be. Even before the ballot situation, California PI was getting very competitive anyway. The cost of client acquisition 3x in the past 3 years. And the insurance carriers are not as flexible of increasing the payouts and the settlements and so forth. So anyway, with or without this ballot, California became more challenging to have a very successful liquidative practice. So pivoting to other states is definitely an opportunity that you should take advantage of and look into it, especially with the UBE license, where you hire one attorney that is licensed in one of these 39 states, and you literally have a license to practice nationwide almost. So we highly recommend that. We set up those situations before. We create the structure, the virtual staffing. We do the online presence in those states that makes the firm look like they completely reside within the state and operate within the state. Client retention, client referrals, all of those things are pretty much we help set up. So these are essentially some of the ways for the firms to be able to handle the changes that are coming up in this ballot. So just quick review. Start looking and entering into other practice type, which employment is the most desirable practice type so far, expanding to other states that are available and the financial supports those decisions. And the third is also being able to reduce your operation costs locally by utilizing a lot more technology. Like right now, we have a law practice.ai, which brings AI into the law practices to be able to reduce intake costs, demand writing, drafting, document collection, and basically reducing your cost drastically by using those technologies, using virtual staff to do pre-litigation, case management, document collections, litigations, discoveries, and everything against virtual staffing is another way to reduce the cost of operations and liabilities and so forth. So those are essentially the ways to be able to get prepared for what I would categorize as this major earthquake that is on the way. I mean, nobody's ever sure about earthquakes, but to me, this November ballot is a major earthquake that most likely would happen. So these are some of the ways to get prepared for it, among other things that you can do. But these are our major recommendations to be able to get ready for that. So I wanted to open up for any kind of questions any of the attendees have that I can possibly answer those. So Haley, if you want to, if anybody has a questions, feel free to drop it out into the webinar chat, and I'll be happy to answer that. Somebody
We
has,
have one question. If the
go ahead.
Fairness for Victim Ballot initiative passes this November, how should firms immediately adjust their intake criteria for auto-related accident cases?
Well, the intake part is really not changing because the qualifications to be able to claim, have a claim against the defendant and insurance company and so forth is all there. It's just that when you are essentially limited to 25% of the net recovery, it's going to be very challenging to operate, especially in the high cost area in California. Is not feasible. Even if you're 100% virtual staffing through LegalSoft, it's still going to be challenging to operate based on those conditions. Another
We
question. Go
we
ahead.
have another question. Knowing that insurances are using AI to find reasons to deny a $10,000 claim, how will LegalSoft add value to my firm against those scenarios?
Well, this is just another way that insurance companies are basically, I mean, everybody is on this bandwagon to basically make all PI cases go bad and reducing a lot of these PI activities within the California. So this is just another way to do that. Your way of you can basically turn around and use AI right against them in the same way if you're using the right AI tools and any of the techniques that will identify that they are basically using knowledge base to deny cases. As I said, it's going to be an ongoing battle now between the carriers, the Uber and Lyft guys, and so forth. So that's why you need to take a bigger actions and then just trying to figure out how you go around the situation.
We have Edward Braun who'd like to ask a question. Edward, you can talk now. You can
Uh,
unmute Edward. Edward?
uh, you want to just
Okay.
type it in? I can answer it if you type it in.
Okay, we'll move on to the next question.
Uh, I have a question
With
about is this retroactive? No, it's not going to be retroactive based on what we know today. That's why you see also a huge boost in PI ads from major firms because they're trying to capture as many cases as possible before the November 1st. But from what we know today, is not retroactive unless something else hit that we don't know about. But uh, you're seeing a lot more activity and expenditure from big PI firms in California because they also believe that could happen.
We have a question from an anonymous attendee. Does dashcam footage make a difference for my cases as they add hard to understand scenarios to the case in order to be mistakenly disqualified by AI?
Yeah, absolutely. The dash cam is always been a great evidence to support the claim and the demand, and it's very difficult to deny the video footage that shows what happened and how it happened and who's at fault. So yeah, the dash cam is always, but it's just like any other video. It could also work against you if it doesn't support the claim. But for most part, if you're using it as evidence, it will support the claim.
We have another question. Could medical providers refuse to treat lien-based patients if reimbursement is effectively capped?
Oh, absolutely. And this is one of the situations where Medicare, Medi-Cal, so forth is also going to get hit because for those people who get denied treatment, they got to go to Medicare and Medi-Cal. So that's those going to go up and it reduces the medical bills and so forth. But yeah, medical provider can definitely refuse treatment if they know that mm, is not going to be cost effective for them to provide the treatment, unlike the opposite, which is has been going on, where they essentially help build up the case by having more and more treatments because they know end of the day all of it's going to get add up and it's pretty much uncapped, even though it's capped at certain point, but compared to what's going to about to happen is pretty uncapped at now.
We have another question. If you are a solo attorney and may not know how to pivot from PI, how would an attorney go about shifting practice areas?
It's almost like I would say when you decided to become an attorney and you decided, okay, up front, I want to become an attorney. So you researched and you found out, yeah, this is something I like, this is something I want to do. And then when you went to the law school, which law school I go to, and then when you come out, what kind of a practice is the exact same continued education, continued process. You need to almost understand it's almost like if you're a solo practitioner, you're a PI, and this thing could happen. You almost want to not pivot into another practice type. And it could be employment, it could be anything else. Um, you should start researching now about almost market researching, understanding what practices are valid now, what is, those mentions from the practice, the business of law that I mentioned about the availability of the market, how available are those cases, uh, what's the cost of client acquisition, what's the average fees, what's the time frame from intake to settlement. You got to do that entire research, and I would do it on 5 or 6 different practice types. I have attorneys in my office almost every week, and they go out basically with the same recommendation. It's almost like you want to pick a major in university. You don't know exactly what you want. You want to see what's the best to do. You go research it, and now with all these AI tools, that speeds up your research like 100x. So I would recommend start researching 5 or 6 different practice types. And also, again, the expansions into other states for any kind of practice type is always a wise thing to do. You don't want to limit yourself to one state. So any scenario you take, the multi-state practicing should be part of it. You should not be stuck just to one state practice.
We have a question. I have heard multiple iterations of the ballot measure. My understanding is that both attorney fees and medical expenses will be split through 25% of the settlement funds. What
Right.
is the current proposed ballot measure?
It is the 25% cap for medical and legal fees. So basically, is asking the voters if they want to be okay with 1/3, the 33%, or they want 75%. That's what makes it really tough because they're really capping it to the 25, which is extremely unreasonable and is going to make a lot of, I mean, even the voters, even the average citizen is not going to benefit from this, really. But nevertheless, just going to limit uh, what the attorneys and medical providers are able to provide. So they're not going to get the same level of service and the care, whatever, uh, the ones who vote for this ballot to pass.
We have another question. What would happen if I file a claim against the at-fault party, but the insurance company later determines that both drivers share fault?
Well, they this is not so uncommon. This is what the 50-50 is basically the insurance company say both parties are equally at fault. Um, and then you go into that settlements negotiation, proving that somebody is a 51% at fault and I'm at 49, is another technique that the insurance companies and the underwriters use to not pay for damages and send you back to your own insurance to pay for you. And sort of like we take care of our own, you go take care of it with your own insurance company. Uh, but you basically just got to use evidence. Again, this is what the dash cam thing comes in, or any witnesses, or any other AI illustrated proof that shows that the other party was at 51% plus at fault, so their insurance can pick up the bill.
We have another question. What would be the best way to approach lien negotiation based off this cap?
Oh, I don't think there's going to be any lien negotiations. There's not going to be enough money to go negotiate. Um, Usually, the lien negotiation that happens today is almost like, all these medical provider, let's say hypothetically, they put in a $5,000 claim on the case, and through lien negotiations, they're going to get maybe 2,500 or 3,000 of their total bill. They're literally just not going to be enough money to go around to reduce it. So I think the lien negotiation and lien reduction is going to be the thing of the past. You know, there's not enough money to negotiate.
We have another question. Do you project the ballot measure to negatively affect bigger firms or smaller firms?
Well, it depends to how the firms are set up. See, there's still some firms are set up very traditionally, the large firms, which has a huge overhead. A lot of attorneys, a lot of local paralegals, case managers, and so forth. Not a lot of technology, not a lot of streamlining processes and workflow processes and KPIs and all of the stuff that we usually go into the firm and make changes for. If they and you can afford to stay that traditional when the settlements are big and you're getting big chunk of it. Those are going to be the one that will be mostly impacted because if you lose basically 50, 60% of your revenue and your fees, you're going to quickly go around the building and find out who you need and who you don't need and who is overpaid and who is underperforming and so forth, and you start cutting things off. So uh, that's what I said. One of my recommendations is like immediately, regardless of this ballot or not, you need to go look at your expenses. And the local expenses are usually your biggest expense item on your P&L. So finding out what area, like in LegalSoft, when we engage with a new medium to larger firm, we start with the organizational chart, and then we identify every single position from operations, from intake, from pre-lead, case management, litigation, whatever, which area and how many resources we can convert from local that cost average of 10,000 a month per person to virtual staff of 2,500 per person and no employment benefits and insurances and so forth. So they need to do that regardless, but the bigger firms get impacted the most and they need to react more quickly. The smaller firm going to have a harder time getting a case because it's just getting that competitive. The cost of client acquisition in California in the past 5 years gone for personal injury is gone from $1,200 into upward of 7 to 9,000. So imagine if you were commuting to work and you were using, gasoline for $2.50 a gallon. Now it's $15 a gallon. You basically cannot afford to drive anymore. So this is what the situation going to be, or it is right now, even with the PI firms, is acquiring new cases is 5 or 6 times more expensive than it used to be.
Okay, we have another question. Would this end up being where an injured party gets medical care through their private insurance, or Medicare and lawyers keep the entire 25%, or will the insurance companies always want to subrogate for what they pay in medical services on a PI case?
Sure. So the first part, yes, absolutely. The injured party, no matter what, if they're not going to get covered and the doctors on liens guys are not going to provide the services, they're going to go to their insurance. But there is deductibles on that. There's a coverage about that. There's some things they cover, some things they don't cover. So that itself becomes a challenge, even when you have a good insurance. So that's one challenging, but that's the first thing the go-to is going to happen. And the Medicare and Medical, again, like I said, they're going to also have to pitch in and do some of the service providing from the medical side. But a lot of those medical providers who were counting a lot on uh, patient from injuries, the MVA injuries and those things, they're all going to have to adjust too, because that portion of their business is also going away too. I know chiropractors and orthopedics and MRI centers who more than 60% of their existing revenue comes from referrals from the law firms. And again, there was money to go after, but that's all going to go away. So they need to pivot somehow on their own as well.
Follow-up question, but will insurance want a piece of the 25%?
Yeah, they're going to come after that too. If they have actually expended, their resources and money providing the services, they're going to be competing for the same 25%. But again, it goes back to it's not enough for anybody to get a piece because now you have like three organizations fighting over 25% that used to be almost 67%. So it's just not going to work out. I mean, there's going to be a bunch of people chasing the money that doesn't exist. See, there are some states already have some rules like this. I mean, looking at the state of Florida, they have a thing called PIP, which basically is a state bar and state approved initiative that has been in effect for, I don't know, 10 years, that any personal injury accident that has less than $10,000 in PD, they have to go to their own insurance and work it out, and they can hire an attorney. So they made that rule, which has eliminated about 30% of our cases. And it gives the insurance companies an opportunity to resolve the issue before the client can actually go and retain an attorney. So a lot of states are coming around and doing things to basically benefit the injured, the plaintiff, and themselves by making sure medical providers and attorneys are not walking away with a lot of money. But you have to be selective. What do you do in what state, in what shape or form? And that's part of the strategy.
We want to invite everybody to offer their last questions. We're coming up on time. If you have a final question, go ahead and pop it in the chat. We'll give people one more minute. Hamid, if you have any final thoughts that you want to bring together to close.
Yeah, I think the final thought is again about everything they heard, everything they're hearing in conferences, on social media, on the group activities and so forth, is do something about it. Don't wait until this thing actually happens and then say, oh my God, what do we do now? Because it's going to take you a while to pivot to anything, make any changes, streamline, reduce local cost. All that stuff takes time, and you're already busy running a practice, doing a practice. So if whatever you do, you need to start now and get prepared for what's about to happen. Even if it doesn't happen, whatever changes you make right now is going to benefit you financially anyway. So the recommendation is just get going as quickly as possible.
Okay, Hamid, thank you very much. And we really appreciate your experience and thoughts on the matter. If you want to continue the conversation, LegalSoft is here as a resource. So everybody, I'm going to share a QR code here. Um, just one moment.